Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I'm your co-host, Thomas Vick, joined by my co-host, Seth Wilson. How are you today, Seth?
Thomas, I'm doing great. We were just chatting a little bit about how by the time you get to Friday, your brain is a little bit fried sometimes. So I have a feeling there'll be a few misspoken words today because we've had a lot going on this week around the office. It's always a lot of fun, though, and always a good time to catch up with you and see how things are going. And I saw a couple
Absolutely.
topics. Sorry about that. Didn't mean to
Yeah,
step on you there.
yeah, absolutely. A couple topics that went out in the blog digest. One is when is the right time to do estate planning, and then the other one is uh, estate planning for caregivers. And yesterday, I had the opportunity to speak to some caregivers. So I got invited to be a speaker for um, the Senior Companions program that is sponsored by Catholic Charities in downtown Indianapolis. Catholic Charities has a program where these caregivers will go and sit with an elderly person for so many hours each week and kind of help care for some individuals that need it. And every couple months, they will have a training seminar and provide these caregivers with some information about uh, elderly people. And so, one of the topics that was discussed yesterday was how to avoid scams on elderly people. I didn't participate in that portion of it. I spoke to the topic of powers of attorney and guardianships and transfer on death deeds, and that kind of led into some other topics relating to elder law and Medicaid planning. But I thought it was really good. I mean, it's kind of encouraging to see. There were about 50 people there that met. And we had a group of 25, and then I went and talked to the other group of 25, and it was good. I mean, being in a group of 50 people who are taking time out of their day to uh, provide care and sit with elderly people, I think it's really really important. So that was a pretty cool thing that I got to do yesterday.
That sounds great. And it's so good to know that these types of services are available because folks in that scenario where they are providing caregiver, or maybe they're the primary caregiver for the family unit, sometimes you just need that extra support and knowing that there's some additional resources out there to provide some encouragement and sometimes just that ability to take a break and not be on all the time where somebody else could come in and take a shift of time and help work through that period of time and give the primary caregiver a little bit of respite would be a good thing. So glad you were able to do that. And I'm sure the information that the participants received was really helpful with that. And that kind of is that hand in glove fit with the other topic that we wanted to talk about, which is, when's the right time to do your estate planning? Now.
Right now, right now. 20
uh,
years ago, 20 years ago was the right time, but also now is the right
That's
time.
right. That's right. And I always tell folks who come in, because I think a lot of folks are sort of apologetic of, oh, I know I should have done this 20 years ago. And I kind of look at them for a second and then kind of chuckle and say, you haven't needed it. So that's a good thing, right? You're still,
Yeah.
you're here. So now really is the time to kind of work through that process. And so much so that even nationally now there is a estate planning awareness week that's coming up. I believe it starts next week, and helping sort of bring this issue to the forefront of, life is unpredictable. So what do you do and how are you getting ready for that? So what are just some general things, Thomas, that folks should be thinking about, maybe the starting along the spectrum of maybe a young family all the way through till we get to those who are a little bit more advanced in years?
Yeah. So starting with a young family, as soon as a person has kids, the parent needs to have a will in which he or she appoints or nominates a guardian of the minor child. That way, a court knows who should take care of the child if something were to happen to the parent. That's probably number one, but also along with that, what happens if the parent becomes incapacitated? then a power of attorney probably needs to be put in place so that, an individual can take care of the parent and also be able to take care of the guardian or the child as well.
Yeah, I agree. And there's often that, do I pay for all of the planning that I'm going to need now and do it all for life? That kind of procrastination piece that may come in because we can't quite make the decision about that. I think really getting that foundational plan in place that takes care of sort of the most important legal considerations, that a guardian has been nominated, a trustee has been nominated to care for any funds that might happen if both spouses are unable to care for their minor children. And really just getting that in place is far more important at this stage of life than thinking about probate avoidance, for example, or something. We're really trying to make sure that if the worst case scenario occurs, there is a plan in place to help move forward. With, as you know, you're already in the worst case scenario there, so it really is just that next least worst case scenario, if that's a thing, in those kind of scenarios. But to have that sort of planned out, that can really help give that young couple some peace of mind.
Yes, and then also kind of the next stage in life, I guess, would be if the kids are now older and are going to college. So that's a point in time where the college kids, the 18-year-old, should have a power of attorney in place so that the parents can continue to take care of the child if something were to happen while the individual is at college or what have you. Um, you know, that's kind of a shocking thing for a parent that now I can't make the decisions. And I know that you've kind of had that experience recently, but the parent can't make decisions for the child because now the child is of the age of majority. So having powers of attorney for healthcare and for financial decisions, that's a really important aspect in that stage of life.
Yeah, and that can be a rude awakening when you go to, even say you're trying to help pay tuition, and the financial aid office won't give you any information because you're not listed as either an authorized recipient as signed by the 18-year-old or as a power of attorney. And so trying to get that done and accomplished before the kids head off to school is really a good technique. And one of the tools that we can do is you can put a time limit or an expiration on a power of attorney so that the 18-year-old doesn't feel like mom and dad are just looking over the shoulder to control everything, but that this is a partnership that, we renew it every year, or we do it for 2 years or something like that, so that it expires. And then when the 18-year-old is now 20 or 21, then that type of information can be released in decision-making authority.
Then I think we're talking about the next stage as maybe the parents are getting to the age of retirement and what kinds of things to be thinking about at that point in time. Then it sort of becomes more pressing in people's minds. That's really where, if they haven't done estate planning yet, as they're thinking about retirement, they think, oh, I should probably be doing some estate planning right now, as well as planning for Social Security and Medicare and all that kind of stuff. So that's a time to be thinking about, maybe be thinking about long-term care, and then also be thinking about, sort of your legacy and how am I going to pass down this wealth, this property in the wisest manner possible. And I'll kind of talk about a Medicaid asset protection trust, Seth, and if you want to talk about a revocable trust, that might be the thing to do here. So when you're in that retirement stage, that's actually a great time to be thinking about long-term care. Long-term care is one of the biggest threats to not being able to pass down wealth to the next generation. With nursing home costs, $8,000 to $10,000. That's a pretty typical amount. That can $8,000 to $10,000 a month, I should say. That's a pretty steep price to pay for long-term care, and that can diminish an individual's life savings rather rapidly. So to avoid that, you can kind of plan to put some money to the side in a Medicaid asset protection trust, or at least put a house into a Medicaid asset protection trust so that the house is protected and doesn't have to be put up for sale or rent if an individual is placed into a nursing home and the individual applies for Medicaid. It's a way of protecting assets so that they're not going to have to be spent on an individual's long-term care. And there's a lot to that, but that's a great time while a couple or an individual is healthy, kind of close to that 60 to 65 years old range. They can be thinking about, instead of maybe not having a long-term care insurance policy, maybe establishing a Medicaid asset protection trust so that assets are preserved for future generations. So that's the time to be thinking about that, but also a time to be thinking about a revocable trust.
Yeah, and they work hand in hand because the asset protection trust is an irrevocable trust, meaning once it's set up, it's sort of set up. And I think we've talked in past episodes about sometimes where you can adjust those if necessary for the right reasons. But largely, I no longer control the asset if it's an irrevocable trust and I don't have anything to do with it other than maybe I have the right to live there or something like that. So that's a little bit of a distinction from a traditional revocable living trust, which is you essentially titling your assets into the trust and becoming the steward or the trustee of that trust, managing that trust for the beneficiaries, which are initially you as the maker of the trust, and then your eventual beneficiaries who are listed in the trust as to those who will receive the property held by the trust at the appropriate time. And the conditions that you can place in that as to, okay, you got to sort of meet this requirement of the trust before you can get those funds. And maybe that's an age limitation or a life station limitation, such as, being a productive member of society and gainfully employed and those kind of things. Or even addressing scenarios you may not know, or know about now, but might be a place in the future where somebody is incapacitated and receiving benefits may jeopardize what types of benefits they are already getting. And so you can kind of set those funds off in protection. So there's a lot of things that you can do within that trust. And I think this kind of covers that period of time where you are starting to gain some assets and think about, okay, now I've got all these little things going on, my primary income, and maybe I have a side hustle here and formed an LLC, or I've got some investment property. Those are all things that need to be kind of addressed through the trust and sort of business to business succession ideals of, okay, what do I do with this? Does my spouse sort of have enough information to know how best to manage this if something does happen to me? Do they have the right to access the bank accounts? Just the real practical things, the legal things that need to say, yes, this person is authorized to take this action in this scenario, right? So that's what, from the lawyer perspective, we enjoy putting all those puzzle pieces together. And again, providing that plan that gives you peace of mind that, okay, if something happens, this is going to go into effect and it'll be ready to go. And that's the beauty of the trust, is it can be very flexible for that and really carry out the terms that you want, especially if there's sort of a life during life incapacity, whereas a will only comes into being after you've passed. That's great, but it doesn't really address that during life incapacity.
Yes. One feature that I love about the revocable trust is that you can change it. So if you got a married couple that's doing estate planning and doing a revocable trust around that time of retirement, they still have 20, 30, maybe 40 years to live. And there are going to be changes in their lives between now and when they pass. So you're not binding yourself to, you're not writing everything in stone. You're really allowing that flexibility, like you mentioned. And I think that's one of the great features of the revocable trust.
Yeah.
So, yeah.
I agree. And I can't tell you how many folks that you meet now who have moved into the community to be with their kids and their grandkids. and they may have moved from a different state to Indiana to follow the grandkids. They call them grand followers or something along that line, which is so great to see that family unit being together and working through that. And I admire those folks who are able to do that and kind of pack up what life they had built in their world, and now they're following everybody else where that is. But oftentimes that means we need to look at the estate plan. The house that you grew up in may not be the house that you're transitioning to the kids now, and what does that mean, and how is it addressed in your estate planning documents. And so it's great because it leaves that flexibility in the document, and typically you can amend that trust to just be governed by the new state's law, because that's where you are. Get your powers of attorney up to date, and it's usually a pretty straightforward process at that point.
Yeah. So Estate Planning Awareness Week, October 16th through the 20th. I'm not sure how we're going to celebrate, but a momentous week in the lives of estate planning attorneys. So excited that October 16th through the 20th is Estate Planning Awareness Week.
Yeah, I wasn't really aware of that. So now that I am, I better make other people aware, right? So another holiday, so to speak, but really there is a great deal of importance to having your thought process circle back around to, I really do need to get this reviewed and updated. And this time of year in the fall is always a great time to do that, as we're heading into, kind of settled into the back to school routines. And you're thinking through, okay, I got to get ready for the new year in terms of my next year planning. Make sure that getting your estate plan up to date is on that list. Review those beneficiary designations. If you had a job change, look at those accounts, make sure they're rolled over appropriately. All of those kind of things that are really just part of managing what you've been entrusted with and stewarding those assets well.
Very good, very good. Well, tell everybody how they can reach you, Seth.
We are located up here in the heart of Hamilton County, right in downtown Noblesville. And that's the easiest way to find us is our web address, noblesvilleattorney.com. How about yourself?
And my name's Thomas Vick. I'm the attorney at Vick Law PC in Greenwood, Indiana. And the best way to reach me is by going to my website, vicklaw.org. Well, thanks, Seth, and we'll see everybody next time.
Thanks, Thomas.